by a magistrate in Barlow in terms of Section 77(1) read with Section 78(2) of the Criminal Procedure Act. So today's proceedings, today being the 18th day of January 2022, following our extensive engagement with the parties concerned, today's proceedings relate to one thing and one thing only: the order that was made by the magistrate detaining the accused in Valkenberg. Pursuant to that order, was he entitled to issue that order? Was that order lawful or constitutional? That is my understanding of today's events. Right. I'm going to give counsel, starting with counsel for the applicant, an opportunity to comment on the chronology of events, correct or add anything. If there is nothing you wish to add, say so. Thereafter, I will give counsel for the state, Mr. Manigo, to add or correct anything, because I want to make sure that what I have said is common cause facts. Ms. Nyat, we'll start with you. Oh, sorry. Mr. Mpofu, sorry, man. I'm not used to these virtual hearings. I'm looking at your junior counsel here. I've forgotten about you. Would you care to comment on the chronology, sir, of these events? Is there anything that I've omitted? Is there anything which is wrong? Would you like to comment?
Thank you. Would I request that other people should maybe mute, because I'm getting an echo. I don't know if you can hear me clearly, JP.
We can hear you. Please, if anyone has a microphone which is on, just turn it on. Mute, please. Ms. Nyati, turn your mic. It's on, and I can see.
I don't have a mic in front of me, just a computer in front of me.
That light is red, ma'am. It can only mean it is recording.
Right.
And mine as well is recording, but I'm presiding. But let's carry on, Mr. Mpofu. We can hear you.
Thank you very much. Yes.
Can everyone hear Mr. Mpofu? Can everyone hear Mr. Mpofu?
Yes, sir.
Thank you very much. Carry on, Mr. Mpofu, please.
Thank you, Honorable Judge President and my lady. I agree with most of what the Judge President has set out. I just have three comments, one comment and three corrections.
Yes.
The first one is on point number 1, where we say the National Assembly building was set alight. That's where the comment is. We'd like to say the National Assembly building caught fire. We don't know what was the cause of that.
Thank you. It caught fire. Let's correct that. Thank you very much, Mr. Mpofu. I apologize.
Thank you. The second one is at point number 4, just to indicate, Honorable Judge President, that even the first appearance of the court was also before Magistrate Mbalo.
Thank you very much, as the record shows. Thank you very much, Mr. Mpofu. Any other points, sir?
The third one, I think the Judge President, that's a slip of the tongue.
Yes.
When you refer to the appearance on the 15th, the JP said in the bail appeal, that was the bail application.
I beg your pardon. On the 15th on Saturday. You're absolutely right, Mr. Mpofu. Thank you for the correction.
Thank you. Apart from that, I'm in 100% agreement with the summary.
Thank you very much, Mr. Mpofu. Mr. Manigo, is there anything that you would like to correct, or have I omitted anything? Have I added in any respect? Because I want these facts to be common cause.
My lord, my lady, the aspect of the charge sheet being presented to the accused at his first appearance, the charge sheet, the charge of housebreaking and arson at that stage were preferred against the accused, and he appeared with those charges.
On the 4th of January, that may well be so, but was he furnished with a charge sheet on that day?
My Lord, ordinarily in magistrates' courts proceedings, the charges are explained to the by the court.
The prosecutor, right?
No, by the court.
By the court itself.
You're being charged, and so you
Yes.
have to apply for bail. So that is the procedure that ordinarily takes place in the
Right.
magistrates' court. Whether the court had recorded it or not, I don't see it on the recording, but that ordinarily would be the procedure.
Yes. But is it correct, Mr. Maniko, that the formal charge sheet was prepared and given to him for the first time on the 11th of January
My Lord,
2022?
he was aware of the charges.
Yes, relating to count 1.
Relating to count 1 and count 2. The count of housebreaking with the intent
Yes.
to commit an offence.
Schedule 1 offences.
Together with the arson offence, he was
That's
aware
right.
of those charges.
Yes. But what about the Schedule 6 offence?
My Lord, what occurred then was that a postponement was requested for
This is spoken. What's happening? Everybody listen. Please mute yourself. Tell me. What about this? Is it connected anywhere? Mute yourselves, please. Right. All right. Apart from that, Mr. Maniko, which is a small technical point, is there anything else you would like to say?
My Lord, one also needs to note that the matter was remanded at that stage for
Yes.
bail information.
Yes.
And then a certificate.
For 7 days.
And a
That's
certificate
right.
was issued by the Director of Public Prosecution.
Nicolette Bell, that's
Specifying
right.
that it was a Schedule 6 offence.
That's right.
Which should be part of the factual.
Yes. Right, thank you.
And,
But it is a fact that on the 11th of January 2022, that was the first time when the accused became aware of the Schedule 6 offence.
that is correct.
Right, thank you
On
very
the
much.
11th.
On the 11th.
That's correct.
And then the report that we're talking about, he saw it for the first time on the 11th.
Yes.
Notwithstanding that it was ready, it's dated the 3rd of January 2022, and it would have been available, presumably, to the
My Lord,
prosecution.
It was available to the state on the 3rd of January 2022.
Available.
Available to the state. at
Thank you
2022.
very much.
That's the court.
My Lord,
Yes, Mr. Bofu.
just for the sake of making sure that the common cause facts are not in dispute, am I correct, my Lord, to assume that Mrs. Boysen is in court?
Ms. Poison is in court, yes.
Thank you, my Lord. Well, then she will certainly confirm to Mr. Nanigo, because he was not there, that indeed, as the Judge President indicated, on the 11th, we actually made a specific request for a copy of the charge sheet to be furnished, and it was indeed furnished. But certainly, as far as the Schedule 6 charge, that was furnished for the first time on that day. So, thank you.
Thank you very much. Right. Mr. Maniko and Mr. Mpofu, thank you very much. Those are common cause facts. Against that background, the order that was made by Magistrate Mbalo was made pursuant to Section 77, read with Section 78(2) of the Criminal Procedure Act. I think for the sake of progress in this matter, I just want to read out the law insofar as it relates to these proceedings, and then I'm going to invite Mr. Bofu to address the court. For the record, Section 77 of the Criminal Procedure Act, the title is Capacity of an Accused to Understand Proceedings. Section 77(1) provides as follows: if it appears to the court at any stage of criminal proceedings that the accused is by reason of mental illness or mental defect not capable of understanding the proceedings so as to make a proper defense, the court shall direct that the matter be inquired into and be reported on in accordance with the provisions of Section 79 of the Criminal Procedure Act. That is the first section in terms of which a referral order was made. That referral order must be read with Section 78(2) of the Criminal Procedure Act, which provides as follows. If it is alleged at criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offense charged, or if it appears to the court at criminal proceedings that the accused might for such a reason not be so responsible, the court shall, in a case of an allegation or appearance of mental illness or mental defect, and may, in any other case, direct that the matter be inquired into and be reported on in accordance with the provisions of Section 79 of the Criminal Procedure Act. That is the law that governs these proceedings before us today. Think against that background, I'm going to ask Mr. Mpofu. Mr. Mpofu, you have filed heads. Kindly highlight those aspects of your heads that you may wish to highlight, and then, in other words, you have an opportunity to argue now. And this relates to your challenge that the orders made by the magistrate Mbalo were improper, they were unlawful and unconstitutional, and they must be set aside. Thank you, Mr. Mpofu.
Thank you, my Lord. Honorable Judge President and my lady, against the background that has been correctly painted, I wish to add that the matter had been postponed from the 4th to the 11th for a bail application, or in the context of bail proceedings. I know that the state has sought to quibble about the nature of that postponement. But as we pointed out, even in front of the magistrate, the learned magistrate, indeed, I'm surprised that Mr. Nogano is that he seems to be still disputing the nature of that postponement, because, if your Lordship and my lady go to page 31 of the paginated papers, you will see that that is the affidavit of one of the prosecutors, Adrian Helder Bloom. And he makes the following submission. In amplification of the said denial, I confirm the following. 45.1, the matter was on the roll for bail information pursuant to a postponement in terms of Section 50(6). So that's the state itself saying that the matter was postponed in terms of Section 50(6). Section 50(6) can only be a postponement related to bail application, bail proceeding. So that seems to be common cause, despite the fact that my learned friend today seems to be going back to their previous position. That background is important for one of the submissions I'm going to make in relation to the gross irregularities that accompany the issuing of the certificate. And it is this: apart from anything else, those proceedings were irregular and they were also prejudicial or in violation, actually, of the right of Mr. Mafe, of the applicant. In that, Section 50(6)(d) says that the bail application proceedings must be postponed for 7 days at a time. In other words, the legislature was very clear in the protection of the rights of accused persons, say that even if, in theory, the postponement is needed for a long period, but it can only be 7 days at a time. In other words, the state would have to come back and say, well, we still need another postponement. In this case, the proceedings were postponed now from the 11th of January, as we all know, to the 11th of February, a period of 30 days, which is more than 4 times the statutory period allowed. Now, that on its own is a gross irregularity. And it would seem, I cannot enter into the head of the learned magistrate, but it would seem that there was a confusion about the 30-day that is referred to in Section 77, 78, and 79. So that was the postponement, but that negated the 7-day limit that is in Section 50(6).
Mr. Mpofu, can I ask you this question? Let us say indeed there was confusion before the magistrate as to why he sat in court on that particular day, whether it was for purposes of hearing a bail application on that day or for purposes of referring the accused person for observation. There doesn't seem to be any reasons, cogent reasons, given by the magistrate why he preferred an order whereby the accused will be referred to Valkenberg for observation and did not consider the bail application. Let's just work with that version that there was confusion. The accused says, I want to be out of prison. I'm entitled to bring an application in terms of the Constitution. The state says, no, we're here to commit you to prison or to Valkenberg prison. There doesn't seem to me to be any explanation given on the record why the magistrate preferred an order that he made and did not entertain the bail application if he was faced with those two conflicting considerations and he didn't remember why he sat in court on that day.
Yes, thank you, Judge President. And one has to just go to the trite proposition, to the very trite proposition, Judge President, that bail can be brought at any time. And that is why the Honorable Judge President was prepared to hear us on a Saturday, because everybody knows, even those who are not lawyers, that a bail application in theory can be heard even at 3 a.m. because it affects the liberty of an individual. So I would agree with that irrespective of whatever the appearance was for, if the accused raised his hand on that day, let's say for the first time, and simply said, I want a bail application, then that had to be entertained. I agree fully with that.
Should we not, this is my second question, because I'm going to keep asking you questions, and I have no doubt my learned sister has a number of questions as well. Should we not, in interpreting Section 77, which says if it appears to the court, should we not be getting guidance from the Mental Patients Act? Sorry, the Mental Health Act, Mental Care Act. There is a provision there which relates to 72 hours assessment and subsequent provisions for further involuntary care, treatment, and rehabilitation. My understanding of that provision, an accused person who appears to be having a mental defect or suffering from mental illness must be observed for a consecutive period of 72 hours. In other words, my understanding of the section, no judicial officer can just look at you and say, I've taken a good look at you, you belong to Valkenberg Hospital. It must be based on cogent information, objective information, not on the judicial officer's whims.
That is correct, my lord, but apart from that, you take into account the provisions of the Mental Care Act, therefore, that's objectively, and again, one doesn't have to be a lawyer to understand that between the second of, between the time of the arrest of the applicant and the alleged observation, at whatever time, let's assume he was arrested at 12 midnight at the second, and examined at 12 midnight on the 3rd. There is no 72-hour period in that space. In the space between the 2nd and the 3rd, you will not be able objectively to find 72 hours. Because 2 days is at best 48 hours. So at that level alone, the provisions of the section would not have been met. But more than that, my lord, the words "if it appears" cannot mean that you just look at a person and make a conclusion. It is common cause now on these papers that Mr. Mafe did not even utter a single word. The learned magistrate did not even talk to him, even about other unrelated issues. And therefore, the word "if it appears" must mean if it appears reasonable or to a reasonable judicial officer. Number 3.
Sorry, Mr. Mbok, before you go any further, there is a question from my learned sister, so I'm trying to control the proceedings because you are not here, you are in Joburg.
Yes.
Right. My learned sister has a question for you.
Good afternoon, Counsel.
Good afternoon, my lady.
At page 64 of the bundle, there appears the single-page assessment which was done by Dr. Zandile Mafe. Now, it's common cause that the referral or her recommendation, page 64, as at page 64, was available to the state prior to Mr. Mafe's first appearance.
That's correct.
I've also looked at Mr. Mafe's founding affidavit, where he chronologically sets out the circumstances prior to his arrest, his personal circumstances, and certain circumstances post-arrest. But nowhere in that chronology does Mr. Mafe at any stage say that he was taken to a facility for assessment. And
That's correct.
in fact, he seems to be silent on this. The state also, in their papers, do not confirm that at any particular time Mr. Mafe was seen by Dr. van Tonder. So my question at this stage is, it seems that the presiding magistrate would have based his decision, if he was deciding between bail, considering bail, and a referral in terms of section 77, that he based that referral purely on the document presented by the state on the 11th of January 2022.
Yes, that is correct, Alex. There was nothing else.
Right.
And
Affidavit, no oral evidence.
And at any stage during that proceedings, because it doesn't seem to be evident from the record, was Mr. Mafe given an opportunity to either refute or challenge that report in any way?
No, my lady, in two very important ways. One is by the nature of the ambush nature in which this document was produced, on the fact that it was, it's common cause now that it was in the possession of the state for more than 7 days, despite the fact that one can understand from the third, but as of the fourth, Mr. Godla appeared as a legal representative officially for Mr. Mafe. He was still not finished with this document. In the ensuing 7 days, the document was not finished, and only less than an hour, which is now common cause, before the hearing, the document was finished. So that poses 2 or 3 questions. One is the one we've spoken about the 72 hours. Second one is the non-finishment of a document by the state of all people by the state to an accused who is represented. Well, in fact, even if he was not represented, it wouldn't make it better. It might even make it worse. But an accused who is represented and the legal representative will not finish the document. But the third issue goes to the core of the irregularities that we wish to address. It is, if there's something worse than a gross irregularity, then here it is. It was then impossible, literally, and I say that with no fear of contradiction, for Mr. Mafe to meaningfully refute the diagnosis, if you can even call it that, of Dr. Van Donner. Because that would have, Mr. Mafe is not a doctor, I'm not a doctor, Mr. Gorda is not a doctor, Ms. Nyati is not a doctor. The only way Mr. Mafe would have refuted this would have been to avail itself to a private psychiatrist of his choice. That opportunity was effectively denied by a court of law in simply making a pronouncement without as much as saying, well, Mr. Mafe, what have you got to say? But let me close that by saying, to his credit, Mr. Mafe said to me that I do not understand this. There is nothing wrong with me, and I would like to be released. And in the discharge of my duties, I conveyed this to the court. So one thing that the learned magistrate knew was that Mr. Mafe disputes this through the words of his legal representative. Thank you, Madam.
Right, thank you. Mr. Mpofu, do you have any further submission at this stage? I will go back to you, and obviously you have a legal team present in court. Do you have any further submissions at this
Just
stage?
one more, Honorable JP. It is that from the wording of the sections that the Honorable Judge President read out alone, putting aside even irregular and illegal with respect to conduct that we have referred to. The wording of the sections do not permit the learned magistrate to have issued the order. The words, if it appears, we have already spoken about. But the other words are in criminal proceedings. And the third one is, which is not in our heads, about the learned judge president referred to the inability to advance a proper defense. Now, those three things read together make it abundantly clear that that section is applicable in criminal proceedings. We have cited authority that shows that bail proceedings are not criminal proceedings. They are proceedings sui generis, and therefore, and the issue of the ability to mount a proper defense does not even arise. In other words, the order, apart from anything else, was premature in law, because this was not the stage at which, according to the applicable law, such a determination can be made. That is the only thing I wanted to add, Judge President and my lady.
I'm glad we have added something because that is leading to the question which I have for you, Mr. Mpofu. On a proper application of the Plascon-Evans test, you are well familiar with that. The allegations contained in the founding affidavit deposed to, they are on paragraphs 23, 24, 25, 26, 26.1, 26.2, 26.3, 26.4, 27 and 28 of the founding affidavit. I searched in vain in the answering affidavit for any answer thereto. On a proper application of the Plascon-Evans, what is your submission? Those allegations stand because there is nothing to contradict them. Not so.
My Lord, if there is such a thing as a double Plascon-Evans rule, then it applies here. Because remember that the state has had two opportunities to respond to this. Because on Saturday, they submitted an answering affidavit where they did not deal with those allegations, those factual allegations. But as luck would have it for them, we submitted a supplementary affidavit on Sunday and Monday, my Lord. And therefore, even if that had been an inadvertent omission,
yes,
they could have taken advantage of the supplementary affidavit and then correct their mistake. But on both occasions, they have failed to deal with those amendments. It is very clear that the supplementary affidavit is supplementary to the main affidavit.
yes.
Therefore, they could have had a second, what other respondents don't have, which is a second bite at the cherry. They had that opportunity, and yet it was so. Your Lordship and my lady can be 100% sure that on the Plascon-Evans rule, those amendments must stand twice.
Well, I don't know Plascon-Evans. Maybe you'll give me a lecture one day. Mr. Mpofu, this is a housekeeping matter. I've been asked that I should ask you to lower your volume, please, on your laptop. It creates the echo. I'm not an expert. That's what I've been asked to convey to you. Okay. Let's look. Yes, I've been asked, please just lower your volume on your laptop. It creates the echo. Don't switch it off, please. Just lower your volume.
Thank you. I'll try. I'm less of an expert than you.
All right, but you are certainly better.
Oh, yes, I can.
Let's go to your amended notice of motion. You want the following today. One, are you there, Mr. Mpofu?
Yes, is that better, the volume?
Yes, for me it is better. The echo is gone and I can see everybody, including journalists, nodding with approval. May we please go to your amended notice of motion? I want to go through the prayers that you want to do. Your amended notice of motion. Please, Mr. Mpofu.
Yes, I'm there, my Lord.
If we are with you, you want the following. One, an order dispensing with the forms of service. In other words, that this matter is urgent. I don't think anyone can seriously contend that it is not urgent. So you want that order, that this matter is urgent. You are entitled to come to court today. Again, if we are with you, an order setting aside the referral of the accused to Valkenberg Hospital in terms of Section 77 of the Criminal Procedure Act. It should be 77 read with 78(2), an order declaring that that was unconstitutional and unlawful. You want an order releasing the accused on bail. We are not going to do that today. Obviously, the light arrangement that was made, this is not a bail application. The bail application is set down for hearing on Saturday, right? And this is a civil matter. Normally, you would ask for costs. Do you have any submissions to make in respect of costs? This is a civil matter. It's not a criminal matter, this application.
Yes, my Lord. Firstly, I'd like to say that I agree with the summation that bail is inherently urgent. And as far as prayer 3 is concerned, my Lord, in line with the arrangement, we understood that it will stand over until Saturday. So it's almost a two-part approach, yes. Now, as far as costs are concerned, my Lord, well, first let me say, under further and alternative relief,
Yes.
that matter can be addressed. Let me make the following submission, my Lord. Mr. Mafe, as far as we appear for him in the criminal matter, in the bail application specifically,
Yes.
we appear pro bono for him in the bail application.
Yes. Carry on, Mr.
Subject to what my learned friends have to say, I would propose that in respect of the civil matter, which is a different kettle of fish, he is entitled to his costs. And my Lord, with the greatest respect, to the extent I know, I don't have to get into details, I know that there's some fundraising efforts to assist him and so on. So we would be entitled to the costs. Oh, Your Lordship, of course, knows that if it turns out that we have to do the civil matter on a pro bono basis, ethically we will disclose that to the taxing masters and all those kinds of people. But right now, my Lord, I would argue that we are entitled to a cost order on a punitive scale between attorney and client. And on the basis that, my Lord, this appearance, Your Lordship has already made the reference to Plascon-Evans. It is not clear why the matter is being opposed if the factual amendments are common cause, as set out by Mr. Mafe. And the law is understood to be, as was confirmed Mr. Helder Bloom in his own affidavit as a representative of the state. Then what are we here, my Lord? Once the Honorable Judge President had alerted the state to the deficiencies, the inexplicable deficiencies in this referral, then a reasonable state that cares for the liberty of the person as guaranteed in Section 35 of the Constitution would have, even if mistakes had been made, we all make mistakes, they would have then realized that this is a completely irretrievably illegal referral. And yet they have persisted, and we are here today wasting the time of court. In all that period, Mr. Mafe is sitting legally at Valkenberg, and he has not had an opportunity, let alone bail. He has not had an opportunity to apply for bail. This is now the day today is the 17th, my Lord. Man, as the Lordship pointed out, was arrested on the 2nd. So more than 2 weeks, he has had not an opportunity in a democratic state to simply say, I want bail, and be denied or admitted to bail. What is that, my Lord? That is not the behavior. That behavior, the court has frowned seriously upon such behavior on the part of the state. And the court cannot take a whip and do anything to the state. The only instrument in the hands of the court is a punitive cost order. And I would want to add, my Lord, some words should be added to that punitive cost order so that in the future, this kind of abuse of human rights should not be seen in our courts.
Finally, Mr. Mpofu, you are not seeking an adverse court order against the magistrate, Mr. Mbalo. The reason being he is not opposing this application. He has said he will abide by an order of court. Am I right, sir?
That's correct, my Lord.
Right.
And also because we have made the point specifically that under the grounds of review, we do not rely on bias or malice or any of those kinds of things. It's a pure irregularity. Therefore, we will not seek cost. Okay.
Finally, if Mr. Mpofu, we are with you, that this order should never have been issued in the first place. We cannot sustain lawfully the detention of Mr. Mafe in Valkenberg Hospital. He will have to be transferred therefrom, not tonight, it's not practicable, and perhaps first thing tomorrow morning to a normal correctional service facility.
That is correct, Honorable
Sorry, Mr. Bofu, until the hearing or the outcome of the hearing of the bail application on Saturday. Am I right?
That is indeed so, Honorable Judge President. And as I remarked to my learned friends, on a lighter note, my learned friends from the other side, that much as I would have liked him to be in the more comfortable situation of Valkenberg, but that hospital cannot hold him unlawfully. And once the order has been set aside, the logic is quite correct. Then the logical legal consequence is that he must await his bail application in the Folsom Correctional Facility.
Normal detention correctional facility. Thank you very much, Mr. Mbofu. If necessary, we would, or perhaps for the record, there is a medical certificate here addressed to Ms. Boysen relating is by Dr. Jagalash relating to the condition, to the fact that the accused has unfortunately contracted COVID-19. He is being isolated for 8 to 10 days. I think I should mention that for the record. Right. Yes. Thank you, Mr. Mbofu. If necessary, we'll get back to you. Mr. Maniko?
Yes, my Lord, just for the record to say that report has been conveyed to us about the medical condition. As the court please.
Thank you very much. Mr. Maniko, you have the floor, sir.
The first aspect which I wish to deal with is the issue of the lawfulness of the referral. Papers are quite clear. The applicant, they are attacking the rationality of that order, the reasonableness of that order. Now, the basis of the order is, of course, the one-pager, the cryptic note that was provided by Dr. Van Tonder, and that was used as the basis for the referral. Now, I'd like to draw the court's attention to an unreported matter, State versus Lali.
Yes.
It has, however, been captured in Juta's unreported reports. I do have a copy available to both counsel and...
Yes, kindly finish us with a copy, Mr. Maniko. Thank you.
I just want to make sure the annotated one is not given to the court.
Whose judgment is that? Which court is
The
that?
judgment of the Eastern Cape Division in Petition
All right.
Before Judge Hartel and Conseil.
Right. Yes. So it's 2 judges. Yes.
Well, this was also a review judgment, and while the points rather favor the applicants, I'd like to draw the court's attention particularly to paragraph 17, 18, 19, and 20 and 21 of that particular judgment.
Yes,
what it in fact reiterates or perhaps strengthens the applicant's case in this matter is that there should not be scant information before a magistrate considering a referral. The court emphasizes the seriousness and the serious consequences of such a referral. Now, where the state would perhaps have to agree with the applicants is that the one-pager by the doctor was perhaps insufficient. Perhaps more could have been made by defense counsel with regards to their rights to challenge that particular document. But what the Honourable Court in that particular matter said that there should be a medical and factual basis for bringing for such a referral.
In fact, Mr. Maniko, a case in point is that referred to by your learned opponent, Mr. Mbofu, in his heads. I've read the entire judgment by copy. The case of State versus Lupuana, reported in 2014-1, page 503. Especially page 508, paragraphs 14, read with paragraphs 20, page 509. That makes it demonstrably clear. That's a case in point. Let me tell you one thing. Perhaps I would invite your comment. Let's say you're a judicial officer. You are faced with this. Matter was postponed. It's not clear to you the purpose of the hearing, whether it's a bail application, but the legal representative, in this case Mr. Gordon, is present in court. He says, no, I'm instructed to move a bail application. Don't you think, with the benefit of hindsight, the wise thing for the judicial officer to have done was, number one, to postpone the proceedings and give Mr. Gordler and his client an opportunity to move the bail application, rather than going for a sledgehammer whereby the accused is diverted from the mainstream bail application line, condemned to Valkenberg for at least 30 days. That, in my view, was a wise thing to do.
If one were to consider the conduct of the magistrate in this particular aspect, and the court is reviewing that particular order that was made.
That's right.
As what should have been placed is perhaps a greater medical and factual basis for the referral. The referral at the end of the day may have been the correct decision, but the rationality of that decision, reasonableness of that decision there needed to be more. Whether it would be the counsel perhaps addressing the court ex parte, indicating we're having difficulty dealing with these proceedings, we can't consult our client. These sort of factual issues could have been placed before the court. More importantly, the investigating officer could have been called in these proceedings and indicated what his experience of the applicant was during his time of arrest, during his time of questioning, these sorts of aspects. So if the court is of the view that the referral was irregular, and perhaps it is probably the considered view in this instance, the problem is, what do we do from that point onwards? The submissions made around bail applications being or proceedings not being criminal proceedings, I believe that is a rather technical point. What needs to happen is, does the applicant understand the proceedings that he is in conduct? The consequences for Schedule 6 bail application are quite severe.
Yes.
The accused has to place exceptional circumstances before the court, and any court would have to appraise itself that this applicant is following proceedings. So I don't believe the magistrate made the incorrect decision in following the route of Section 77 prior to the bail proceedings. Because down the line, let's play this thing forward into the future. The bail application is conducted on Saturday. The applicant is called into the witness box and testifies, and suddenly there's a clear appearance to the magistrate. This gentleman is not following these proceedings. He's not of sound mind.
That would, with respect, be one of the considerations, one of the factors that the court, hearing the bail application on Saturday, would take into account.
Then not us. Then we're back at square one, because then the bail court will be obliged. It's peremptory. It will be obliged to refer the accused. My submission is...
The problem, Mr. Manigo, is this. The court never even attempted to hear the bail application. That was notwithstanding the insistence by counsel. That, in my view, is a gross irregularity.
Let's consider that point for a moment. If there is an allegation before placed before the court, let's consider the scant information in Dr. Van Tonder's report. Number one, this person is experiencing delusions. Paranoid delusions was the first thing. And then a provisional diagnosis was given of paranoid schizophrenia.
It's impossible to have had a proper diagnosis in less than 24 hours.
No, unfortunately, the record is not borne out.
It's common sense.
Yeah, what we don't have is...
No, Mr. Maniko, I'm not going to let you off the hook here. If you look at the Mental Health Act, that's why we must get the guidance. There is reference to 72 hours, and there is a reason for that. I just finish? The observation and assessment is not just a once-off thing. You don't look at the person and say, in my view, you are insane. in my view, you will not understand proceedings. There is a continuous evaluation, and we all know what happens there. It's professional staff, it's psychiatrists, and that is done for at least 72 hours. That would enable any doctor to file a report which can safely be relied upon by a court. That's not what we're seeing.
My Lord, if I may just address the court on the aspect of the Mental Health Care Act. The purpose of the Mental Health Care Act, that particular observation, is when you are admitting a person as an involuntary health care user. Now, we're dealing here with the Criminal Procedure Act under Section 77.
Yes.
The only thing that the magistrate needs to satisfy himself, if it appears. Now, the only question can really be is the rationality of that decision. Was there sufficient, did it appear sufficiently to the magistrate?
Would it have been irregular for a magistrate to ask a couple of questions to the accused?
No.
Good morning, how are you, sir? If the accused says, go to hell, then you know you're dealing with a lunatic.
No, exactly.
And that didn't happen.
So,
he did not even greet the accused.
So we get to the point, if the court views those proceedings as being irregular, what is then the remedy with respect to those proceedings? Now,
the remedy that I would propose is the following. Set aside these proceedings. Once we come to the conclusion that the magistrate acted unlawfully, the accused cannot be detained with respect pursuant to that order. Does not necessarily mean that the accused is going to be released. He must then bring a formal bail application. And nothing stops the state, Mr. Manigo, from instituting the same proceedings, but it must be done lawfully and properly. That's all we are saying. It can be done at any stage during the trial. And normally this is done by the defense.
My Lord, if I may propose an alternative remedy to what the court has suggested. The setting side of the proceedings, not really, I don't really have an argument there. What I do, however, suggest that the court look at the case of State versus Ramakoka, which is a reported decision.
Ramakoka, not Raposa.
Yes, it's 2006.
Yes.
To SACR 57W. It's a Watersrand decision. I do have copies as well. Fortunately, my Lord, I'm supposed to prepare on short notice in this matter.
No, it's entirely understandable.
But
The court is grateful to you.
I will hand a copy up to the court and to the defense.
What was decided in that case, Mr. Manigo?
My Lord, it's not really a case in point. What was of relevance in that particular case was that an irregularity occurred in the referral in terms of Section 77(1). It was more based on the form of the referral, where the magistrate had referred to a clinical psychologist, and where an error was made by the magistrate in the referral. In that instance, to rectify that situation, the court referred the matter back to the district court, obviously with the injunction that a proper referral process should be conducted. And this is what should happen for Mr. Mafe to the just outcome should be that he be referred properly. A proper inquiry being made, a proper preliminary inquiry being made. Number one, we have the doctor testify in court. Now that we know that it's a dispute, his mental illness is in dispute, we have that doctor testify and justify her finding. That is the problem with that report. It doesn't really give us what sort of observations did she make, what sort of paranoid delusions did she observe in the accused. So let her testify and let the magistrate who needs to make the referral have a proper appraisal of what is happening.
Yes. Sorry, my learned sister would like to ask a question.
My lady?
Mr. Manigo.
Mr. Manigo, it's somewhat bothersome that the report was available to the state 1 day prior to Mr. Mafe's appearance, is there any reason that you're willing to proffer as to why the report was not made available on the first occasion, on the 4th of January, when the accused appeared?
My lady, this is now I'm loath to testify from the bench, from the bar. Sorry. You must remember the genesis of this particular report. The accused
the genesis could not have been very long.
The genesis of the report was in fact the accused. There were certain pre-trial procedures that took place with the accused, and he was referred in terms of those procedures to observe his physical and whether he was a victim of an assault during the proceedings. Perhaps I should just be forthright and say they were pointing out and confession proceedings. Mm-hmm. And he was referred for that purpose, to see whether he had any injuries on his body, the voluntariness aspect.
So it was not a mental referral.
It wasn't. The initial referral was merely, but the doctor, when assessing this particular applicant, then realized that there are certain issues, and these need to be drawn out and given to the state to pursue. Once that report was available, unfortunately, that should have been made available to the applicant. I cannot say anything. By at least the 4th of January, it should have been made available. But I think at the end of the day, we still have to do what's best for Mr. Mafe. And if Mr. Mafe is perhaps a 77-1 candidate where he doesn't understand proceedings, do we subject him to bail proceedings, the adversarial nature of bail proceedings? Let's consider whether a pointing out or a confession is later introduced as the evidence against Mr. Mafe. Let's speculate for now.
Yes.
If that the content of that affidavit has been, or those confessions are as a result of a paranoid or schizophrenia type of scenario, is it fair to subject him to that? My submission is, do the referral properly. If Mr. Mpofu introduces evidence that, or perhaps a family member comes to testify or deposes to an affidavit indicating Mr. Mafe has no history of mental illness, he has no, and we went down to the cells and we consulted with him and he fully understands proceedings, then we can exclude Section 77(1) perhaps. The magistrate could exclude, but that still leaves 78(2), which is the criminal responsibility aspect.
Yes.
Was he criminally responsible at the time of commission of the offence? And that can only, unfortunately, be done through mental observation. Now, bail, the issue of the bail proceedings, this, I think the court at some stage, I can't remember if it was during the course of these proceedings, referred to it as the elephant in the room. If he is unable to understand proceedings and we continue with bail proceedings, that would not be a due process, my submission. My submission is due process would be deal with the referral as it should have been dealt with. Let this court set aside the referral and ask that or refer it de novo to a magistrate to deal properly with the matter, properly ventilate the issues. And if the court then, if the district court decides that a referral is necessary in terms of either Section 71 or 78 or both, then let the court, the accused be observed by mental health professionals.
Yes, Mr. Maneko, thank you. I've got 3 quick answers to that. The first one is this: no to the district court. We can't return it to the district court. There is a reason. Your colleague, Ms. Boysen, indicated that the state intends prosecuting the accused in the regional court. So we will have to, if at all one refers the matter back, it will have to be a regional court.
I'll respond.
Sorry, Ms. Boysen.
Sorry, my lord, just on that aspect. The indications were that the offence was a Schedule 6 offence. The intention was to refer the bail application in terms of section 60. I'm not sure the section now, but the Director of Public Prosecution can designate a regional court. So the purpose of that was to refer the matter to the regional court merely for the hearing of the bail application.
But not the trial.
Not for the trial, so not in terms of section 75, but in terms of the section provision within the Criminal Procedure Act.
Do we know at this stage where the trial will take place? Is it going to be the district court, regional court, or the High Court?
My Lord, the High Court is proposed as the seat of trial. That will be the ultimate forum for the trial.
Right.
So what will happen is once the bail proceedings, assuming we continue to bail proceedings, once the bail proceedings are heard in the regional court, the matter is back on the district court roll, and indictment will probably then be served with respect to the charges.
And the matter will be transferred to the High Court for pre-trials and the usual.
The normal procedures. So the district court will be the proper court to do the referral. But my recommendation would be that it not be the Ms. Mbalo.
Yes, different constituted court. That's what we normally do. Well, the other answer that I have to you, Mr. Mafe, the applicant in these proceedings, is legally represented. His team of lawyers will surely be in a position to engage him. At the moment they have consulted with him, they are instructed to bring a bail application. We cannot deny him that constitutional right to bring a bail application. Nothing stops the state. The law is very clear. On the day, which is Saturday, when he brings the formal bail application, from placing any information that may be relevant to the court. Nothing stops the court. We cannot prejudge what will happen on Saturday. But he has every right not to be pushed out of the bail queue unlawfully in terms of Section 77 and 78 orders. And his lawyers are wise enough to say, no, we don't believe what you are telling us. And usually applications of this nature are brought by the defense. Mr. Boot does that all the time, and other defense lawyers.
Obviously, the wisdom of bringing an application, that's why we have counsel and junior counsel. The wisdom of bringing an application when you're not sure whether the accused can then understand proceedings, I suppose that will probably be dealt with at the bail application.
Well, I will take his word for now. He says he's not mad. He knows what he was doing, and that was conveyed to the court by Mr. Kodla and by Mr. Mbof.
Who on their own argument are not doctors, my lord. But my submission, my lord, is that the court, if the court sets aside this order, that the court when the court refers this matter back to the district court for the referral proceedings, that it be conducted properly. That is the only aspect that the state wishes to emphasize.
No, I understand that, but you understand where I am certainly coming from. The effect of doing that would be to continue to marginalize the accused, for lack of a better word, to push him out of the bail queue unlawfully, in circumstances where he says, I want to move a bail application. And it's his constitutional right.
My lord, his constitutional right. And
yes. Would you like to address the court on the issue of cost?
My lord, this is a civil cost. Let's just look at the history of this particular matter. It started out as an urgent bail application. I think that was contrary to your directives, an urgent bail application was placed before the court. There's a clear practice directive from this division indicating that the court will not entertain bail applications on the High Court trial.
That stems directly from the Criminal Procedure Act, because we don't have original jurisdiction. We only hear appeals.
So now you must then recall the state's attitude then, having full knowledge of the Criminal Procedure Act and the practice directive. The state was obliged to oppose an application brought on that basis. It was then that this application was morphed into a review application, which justifiably so when one considers the
order made by the court.
So it morphed into a review. But now remember, the prayer is in this amended notice of motion the prayers were for the referral, which the state is setting aside of the referral, which the state is not generally opposing, but then asking for the accused to be admitted to bail. The state was obliged once again to issue a notice of intention to oppose, and the court has dispensed with that particular issue of the bail application. This court cannot entertain a bail application. The court can only look at reviewing the decision of the magistrate. So to penalize the state on a punitive or attorney-client scale would not be correct. I would submit that no order as to costs should be made, because we've opposed an application which was incorrectly brought in both sets of papers. So it would be unjust to
Perhaps punitive cost order would be too much, unjust. But what about the normal cost order? The rule is that a successful party is entitled to his costs. And Mr. Mafe, undoubtedly, if we rule in his favor, he will have succeeded on the review application.
He would have partially succeeded, my lord, but not fully, because he raised the issue of, once again, of the bail application, that he be remitted to bail, which engendered the state then to oppose the second application as well.
Yes.
So
Thank
just
you.
to sum up, my lord, my submissions finally are that, number one, that if this order is set aside, that the matter be remitted to the district court, and that to conduct proceedings in terms of Section 77(1) or 78(2) of the Criminal Procedure Act, and hopefully conducted this time properly. If the bail application then should continue, my lord, it's of course state to raise this particular issue once again at the bail application. The other problem now is that the order that he be detained at Valkenberg would now no longer be applicable. So the logical place then would be a referral to Portsmouth. The only problem that we may have is that Portsmouth will require that the accused be isolated because of his positive COVID test, which would take his period of isolation, according to their calculation, the Portsmouth's calculation, to the 24th of the month, which would I think take us beyond the 22nd. So that's just a logistical consideration the court may need to consider. Whether we can, I don't think bail applications at this stage, whether it can be done virtually. But those are the logistical
Anything
considerations.
is possible these days.
But those are the considerations the court may need to consider, and I hope counsel had no contact as well. So, but those are some of the considerations that the court may need to consider logistically in terms of the hearing of the bail application. But if the court rules that the bail application should continue, the state is more than ready to oppose that the application for bail.
Yes, perhaps it's something that Mr. Mpofu and the legal team should consider, given the developments that have taken place, i.e. Mr. Mafe is indisposed, whether the date that has been agreed upon in the light of the requirement that he must isolate, whether that date is fine. Right. Remember where we come from. Once we pronounce that the detention is unlawful, we cannot authorize further detention. We can't, unless the parties have fixed a particular date, bearing in mind what is going on. Perhaps.
And this is one of the big stories that's developing tonight. That case there sitting in Cape Town there, Judge President John Kloppe having some tough questions for the legal counsels, one representing Zandile Mafe and also the state, as they look at really overturning this decision to send him to Valkenberg for medical observation. And Francis, one of the things that's very clear here is that there may have been some serious bungles as far as the legislation legislation is concerned here. But also when you look at his legal team, they're not also getting off slightly.
Yeah, and there's been concession after concession from the state saying, yes, we could have done things differently. He should have seen the report, for example, on which, the basis on which he was sent to Valkenberg. So we will get more information from that. We'll follow proceedings for you. But right now we're going to another developing story. Our correspondent Natasha Perry is